All right, welcome to the first guest talk for our semester. We are very lucky to have Justice Daphne Barak-Erez, who's currently a sitting justice in the Supreme Court of Israel. Prior to joining the court in 2012, she was a professor of law at Tel Aviv University, with whom we have recently entered into a memorandum of exchange. So I should also acknowledge Professor Neta Ziv, who is in fact a visiting professor with us this term. And it is at her invitation that Justice Barak-Erez has come here. Her scholarship has focused on many themes. If you've had a look at the profiles which were sent out, her main areas of interest are constitutional law and administrative law. But she has written some fascinating books cutting across different themes like law and security, food habits, amongst others. So it's a great opportunity for us to learn from a distinguished legal scholar and jurist from another jurisdiction. Yesterday, in fact, Justice Barak-Erez was nice enough to have a sort of informal conversation with my constitutional law class. And I'm sure we can make the most of this session, not just in terms of listening and engaging with the lecture, but also in terms of questions. So we have the better part of an hour and a half, and I hope that all of you will make the best use of this opportunity. So without wasting any more time, I invite Justice Barak-Erez to take over the podium.
Thank you again. And again, when are we supposed to do?
So we can go up to 1 o'clock.
We'll see. Okay. So, good day to everyone. I'm really delighted to be in this excellent and vibrant academic setting. And I'm really grateful for the opportunity to be here and get to know the academic community here. I greatly enjoyed the session that I already had with the students yesterday as a guest lecturer at the Constitutional Law class, and I especially enjoyed the questions and comments. So I will say even here before I start that I would really welcome any comment, inquiry, and I'm even willing to make it in a less formal manner, in the sense that if I say something that you feel that would justify a question even as I go along, I think it can even better the atmosphere and the conversation between us. So I really encourage you to raise your hands and feel free. The topic of my presentation today will be the role of the judiciary vis-a-vis the enforcement of social rights and protection of social rights. Naturally, the presentation will focus on the Israeli case law and the setting of Israeli constitutional law, which I know the best, so I feel more comfortable speaking about my country and also sharing with you some, I would say, stories of cases that may be of interest, but I will try to locate the Israeli case study in the broader context of, I would say, dilemmas around the enforcement of social rights. So I will speak on Israel, but my purpose is maybe to use the Israeli case law in order to broaden our discussion. And I'm very well aware of the fact how important and I would say inspiring is also the jurisprudence on the protection of social rights in India. So I'm not here to tell you about the Indian case study, but you are welcome also to use it when you think about my presentation. So in fact, this was one of the considerations for choosing the topic of social rights. I mean, social rights were always very close to my heart as an academic scholar. This was one of the areas I was publishing in. But as an additional consideration, I think that the importance of social rights in the Indian context was another consideration that I thought about when we try to think what might be the proper subject for my presentation. So, okay, well, enough for too many introductions, and I'll start my talk. I'll just rehearse one again, that the protection of social rights by the judiciary has always been a big challenge in various jurisdictions, considering the difference from the so-called classical model of civil and political rights, as well as the perception of their costly or so-called costly nature. Social rights need budgetary contribution coming from the state in many cases, and for those who oppose their protection by the courts, this is at least classically presented as one of the opposing arguments, an argument that I don't personally support, but I think we should present it as we go along as one of the background themes of the discussion. I will divide my presentation to in a very classical manner. It will include 3 parts. The first part will give you some general description of Israeli constitutional law, so you will understand the location and the context of the general discussion of the constitutional protection of social rights. Then the second part will present the main interpretive approach developed by the Israeli Supreme Court to the right of human dignity, and I will mention at this very preliminary part that the protection of social rights in the Israeli case law was very much developed and built upon interpretation of the constitutional concept of human dignity, implying that we cannot think of a proper understanding of human dignity without at least some or maybe minimal protection of social rights. I will also discuss maybe the problematic nature of this minimal understanding of protection of social rights. But anyway, the second and main part of my presentation will focus on this interpretive method of protecting social rights through the constitutional concept and, in fact, constitutional right of human dignity, which has a special status in Israeli constitutional law, as I will explain. And the third and last part of my presentation will present maybe some current challenges in the implementation of the model that I will present to you, the model of protection social rights through the protection of human dignity. So this is the general structure, and now I will just start following this way. So as I said, in order to present the protection of social rights in the Israeli context, I will just present to you, generally speaking, the structure of Israeli constitutional law. And I'll try to do that also by way of some comparison to the Indian case study, because there are some background factors that our systems share, in the sense that also in Israel we were ruled by the so-called British Empire before independence. Israel gained its independence in 1948, around the time, just a short time after Indian independence. And some of the basic features of the legal system in Israel had things in common with the Indian system, in the sense that we borrowed much from the British rule of law model. We have an adversarial system. We follow precedent. So some of the basic features that I would say characterize the Indian system, characterize the Israeli, the Indian system characterize the Israeli system as well. But in the context of constitutional law, there is one big difference that should be mentioned. When India started its way as an independent nation, one of the first important things to be done was to accept the constitution. India has a constitution from its very early days, and the process of writing the Indian constitution and debating its future content was one of the very important processes of independence. I'm not here to teach you about that, but I'm mentioning it because it's an important factor. And the Indian constitution is indeed a very interesting and even inspiring document, and as a scholar also of comparative constitutional law, I can tell you that we also outside India find much interest in case law coming from India discussing comparative concepts. So here I mention the Indian constitution as something very important in the Indian context. By way of contrast, Israel until today does not have a full formal constitution. The initial plan was to have a constitution. As one reads through Israeli Declaration of Independence, one can see that the initial idea was to have a constitution that will, once again, reflect the basic concept of the national spirit, basic protection of human rights, but for various historical reasons that I will not get into right now. I discussed that in more detail in the class yesterday, so maybe for people who also attended the class, I don't want to rehearse these parts too much because this is not the focus of my presentation now, but I will just say very briefly that for various historical reasons, including a long bitter war of independence, clashes between secular groups and religious groups, the political compromise of the time was to postpone the constitutional project, and rather than enacting or accepting a full formal constitution, enacting a series of what we call basic laws. Basic laws are not regular laws. They are like some kind of super laws. They have, I would say, a special normative status vis-a-vis ordinary legislation. The idea was that our parliament will enact our constitution on a chapter-by-chapter basis. Whenever we have an understanding or a political consensus around one section, one chapter of the future constitution, the parliament will enact that chapter of the future constitution in the format of a so-called basic law, and then it will be a gradual process. Whenever we have a consensus, we will enact a basic law. Eventually, we will have a long line of chapters of the future constitution, and we will eventually get to the stage where we can consolidate all the chapters into one constitution. How all this is connected to social rights? Now I will make the connection. In 1992, so around 40 years after the establishment of Israel as an independent state, and after we at a stage where we already had a long line of basic laws regulating the institutional aspects of the constitutional structure, a basic law on the parliament, a basic law on the judiciary, a basic law on the government, etc. The time has come to enact basic laws on human rights, to enact the Israeli Bill of Rights, something that is always, I would say, the beating heart of any constitution. And in 1992, the Israeli parliament passed two basic laws on human rights. The most important of them is basic law, human dignity and liberty. And here I mention for the first time the concept of human dignity, because human dignity was understood the right to human dignity was understood as one of the most, maybe the central right around which that focuses the protection of human rights in Israel. Indeed, this basic law also mentions specifically other rights, the right to property, the right to liberty, but human dignity was understood to be the main concept, the heart of the protection of human rights in Israel. Originally, the plan was to enact not only two basic laws on human rights, one of them on freedom of occupation in the sense of freedom of trade, that everyone can choose for oneself his profession and source of livelihood, basic law, human dignity and liberty, and there were a few other basic laws in the stage of planning and drafting. One of the planned future basic laws was supposed to be basic law, social rights. So there was a concrete plan to enact a specific basic law on social rights. Then, for new political reasons that I will not now deal with in much detail, due to political controversies, the project of basic laws got into a stage of crisis. It was difficult to go on with this process. Some politicians were, I would say, in a stage of opposition to the very concept of judicial review of legislation. So although they not necessarily opposed the concept of social rights, they said, we are not willing to vote for new basic laws, because new basic laws means maybe more power to the judiciary, because basic laws are usually the source for judicial review of legislation. So again, the message was, we are not necessarily against, the specific proposals. We are not necessarily against the idea of protecting social rights, not necessarily. The thing is that we are not supporting the concept of new basic laws at all, because new basic laws means giving more power to the judiciary. We are stopping at this stage the process of enacting new basic laws and completing the constitutional project. And here, all this led us to a stage of crisis from the perspectives of those who are interested in the promotion and protection of social rights, because we were stuck in a stage where there are basic laws in place, but no basic law that specifically protects social rights. And the question was whether the court has the power, in a formal sense, to protect social rights, to give injunctions protecting social rights, when we know, as a matter of fact, that the plan to legislate a specific basic law on social rights is not going to move forward for the time being. At this stage, very serious interpretive controversies started to take place. Some scholars argued that without express mentioning of social rights, the court is precluded from formally protecting them, and we should wait for better times with a specific formal declaration of social rights. Other scholars argued, well, this is not necessarily the case, because we have a basic law mentioning specifically human dignity, the right to human dignity, and how can we think of having and protecting human dignity in any true sense if people don't have any kind of safeguard against starvation, against, the prospect of living in the street. So the argument was, what we have is what we have, and we must give a true meaning to the concept of human dignity. By the way, so several, I would say, relatively broad interpretations to the concept of human dignity started to be discussed. In order to put things in an even broader context, I will mention that not only a specific basic law on social rights was not enacted, but also other basic laws that were supposed to specifically declare other important human rights were not yet enacted. For example, a very important civil and political right, the right to freedom of speech, is not mentioned specifically in basic law, human dignity and liberty. So, in a similar manner, scholars, jurists made the argument, we cannot think of any true meaning of human dignity without freedom of speech, because people who cannot speak their mind out, cannot express political views, obviously cannot be regarded people whose human dignity is being protected. Interestingly, and here I go back to the issue of social rights, the argument that human dignity necessarily implies freedom of speech and equality was more easily accepted by the legal community. Because freedom of speech, equality are civil and political rights, rights of the kind that have a longer history of protection by the judiciary. So it was relatively easier to understand. I'm not saying that this is the case, I'm just describing political processes in Israel. The argument that human dignity necessarily implies the protection of freedom of speech, equality, freedom of religion, this was relatively easily accepted. But when other jurists tried to make the argument, okay, human dignity implies not only equality, not only freedom of speech, but it implies also some kind of safeguard against starvation, against living in the streets, basic safeguards of public education, etc., then traditional jurists became a bit uneasy about it, started to raise the concern that social rights maybe are something different, because they, as I said in my introductory words, they cost money. So how come that the judiciary will recognize new rights that are not expressly mentioned in the constitutional text when we are discussing rights that cost money? This is, I think, based to a large extent on a very superficial understanding of the costly nature also of civil and political rights, because if you think about a classical, I would say, political right, the right to vote costs a lot of money to the state, because all the election process is very costly, and we will not say that a democracy can survive without protection of the right to vote, although the right to vote costs money. So this understanding or this argument that civil and political rights necessarily are free rights that don't cost any money, whereas social rights are costly rights, and therefore we should be very, I would say, uneasy about their judicial protection. Well, if I stick to the terminology of cost, I don't buy this argument, but this is a classical argument, so it's important to know it. So here is, to start with, the first part of my presentation. I didn't say yet anything about the protection of social rights. I tried so far to locate the next part of my presentation in the broader context of the forms of development of Israeli constitutional law. Just to summarize in a minute what I've said so far, I described to you a system that develops gradually toward having a full formal constitution. This is the main difference between Israel and India in this sense. We still don't have a full formal constitution. We do have a series of basic laws. The basic laws project has not been finalized yet. It includes two important basic laws on human rights, The most important of them is the Basic Law enacted in 1992 titled Human Dignity and Liberty. This Basic Law does not include in the express text mentioning of social rights, but a serious argument has been developed among jurists that in order to give full, meaningful meaning to the concept of human dignity, it should include some level of protection of social rights. The question is, what level? Does human dignity imply a minimal protection of social rights, maybe something beyond that? I can tell you, and here I get to the second part of my presentation, that the view that started to enjoy, I would say, relatively hegemonic support in academic writings around that time, probably also also due to the fact that this was the view that was supported at the time by Professor Aharon Barak, who became also around the same time the Chief Justice of Israel, a very renowned academic, and at the same time the Chief Justice of Israel. By the way, no family relation, but although I also share the same family name, just a bit common in Israel. But he was a very leading figure. Now I can say that he was a very leading figure in the development of Israeli law in general, and also specifically in the development of Israeli constitutional law. And in his academic writings, he started to express the view that as a matter of compromise between the view that completely negates the possibility to protect human rights without, social rights without their express mentioning in the text of the Basic Law, and the other view that says, that would say, well, human dignity implies full protection of social rights, he started to support what he called a middle ground or a middle way. Yes, human dignity implies some level of protection of social rights, but this would be relatively minimal protection, not because I, as Barak used to say, that I or he is against social rights, but he made the argument that if we want to have more than a minimal protection, then we should wait for the parliament to enact the express Basic Law on social rights, and in the time being, the role of the judiciary, because this is also a matter of division of labor between political institutions and the court, the role of the court will be, in the time being, give some remedy, some redress by giving human dignity the meaning that includes also some level of protection, minimal protection. And as I will soon make it clear, this view offered by the most, I would say, influential constitutional scholar of the time, we're talking about the 90s, beginning of this millennium, soon became also the view of the court, led by Chief Justice Aharon Barak, the scholar who expressed these views in his jurisprudence. So, according to Barak, still in his academic writings, and I will soon show you how this was reflected in the case law, according to the Barak, the rights which could be inferred from this minimal level of protection of social rights through human dignity were the right to temporary shelter, at least this, that a person will not have to sleep in the streets, freedom from starvation, access to basic medical service. Once again, having a distinction between basic medical service and maybe full national health insurance, this would need political involvement. And as I said, once again, Barak stressed that he did not oppose the importance of social rights, but believed that their full recognition beyond this minimum required the enactment of further basic laws that would address this issue. This was the view presented, and now I will show how it was, I would say, accepted in the case law. Of course, I will not get into all the cases, but I will share with you some stories of cases so that the more general and abstract concepts that I shared with you so far will become clearer, because they will be located in the context of actual cases and narratives of cases. So the first case that I will mention in which this minimal protection of social rights was accepted is known in Israel as the Gamsu judgment. Here, the court dealt with a case of a woman who sued her estranged husband for alimony for both herself and her daughter. We are talking about a separated couple, a person who had a wife and a daughter, and he just refrained from supporting not only his estranged wife, but also his minor daughter. And to add insult to injury, he also left the country for various years, and the result was that the debt that what he owed to his family became bigger and bigger. At some point, this person came back to Israel, and his family sued him and started to enforce the debt collection through the court system. And that person, who did not have money at this point in his life, said, well, if you are going to take everything from me, I'm going to starve. I will not have anything to support myself. So I ask the protection of the court in the sense that not all my money, not all my salary will be taken from me, but something will be left in order to secure my ability to live in dignity. So this is a rather strange case, or a case that we might feel ambivalent about, because we have here an individual who is arguing for the protection of his human dignity in the sense of his ability to support himself, but he's making this argument not against the government, but rather against his estranged wife and daughter, the same people he was not supporting for years, and at least from his perspective, they could starve as well, unless they got some kind of support by the state. So this is a very uneasy situation to start the discussion around social rights. However, the court chose this decision to be its first decision on the protection of a minimal level of protection of human rights, or of social rights. And Justice Barak, who was on the panel, stated that, and I quote, "Human dignity includes protection of the minimum of human existence." A person, again, he reiterates his view that a person living outdoors who has no housing is a person whose dignity was violated. A person hungry for bread is a person whose dignity as a person was violated. A person who does not have approach to elementary medical service is a person whose dignity as a person was violated. This is all written in the judgment. A person who has to live in humiliating material conditions is a person whose dignity as a person was violated. This is the case with the dignity of every person. This is the case with the dignity of a debtor who cannot pay his debt from alimony. So the court not only says that a person should be protected, but in the circumstances of this case also says the protection would be, in this case, that the debt will be collected from the debtor, but not everything, because it is the duty of the court to make sure that also the debtor has something left in his hands in order to support his subsistence. How should we think about the Gamsu case? The Gamsu decision is traditionally interpreted as a significant step towards recognizing the constitutional status of social rights, because this is the first time when the court says, yes, social rights are part and parcel of our understanding of human dignity, but this decision is also subject, or at least potentially subject, now as a residing justice, I have to be very careful in what I say about court decisions, right? But potentially, this decision is subject also to criticism, at least potentially subject to criticism. Why? First, it accepts only the minimal approach to the protection of social rights, and some would say minimal approach is not enough. Would we feel okay if the court protected only, would afford only minimal protection to freedom of expression? We would not feel okay with a system that gives only minimal protection to freedom of expression or minimal protection to equality. So why should we be happy about minimal protection of social rights? But this is in a more theoretical level. In the circumstances of the case, it's also important to see that this was a relatively easy case for the court, because this was a case in which social rights were protected vis-a-vis another individual. This is not a case in which the state was subject to an injunction, give more budget to poor people. It's social protection vis-a-vis or in the context of private litigation between two estranged parties. So this was a relatively easy place for the court to start, because with such a decision, the government would not feel uneasy. It doesn't mean that the government will have to give even one more extra shekel, dollar, rupee in its budget in order to support the poor. So this is a case in the context of which the government is relatively indifferent. And therefore, this is a relatively easy case to start with. The real question after the Gamsu decision was, what would be the implementation, what would be the application of the same concept in litigation where the government will already be involved and where the actual meaning of the decision will be necessarily allocation of more budget to support the poor. This would be the real test. And the real test came along relatively short time after the Gamsu decision in a case known as the so-called Commitment to Peace and Social Justice Association case. Why do I mention this name, Commitment to Peace and Social Justice Association case? Because Commitment to Peace and Social Justice, etc., is a name of an NGO, and this was a case that was brought to the Supreme Court by an NGO, and this is maybe the good opportunity to mention to those of you who were not attending the class yesterday that the Israeli doctrine is relatively very open and friendly to petitions brought by NGOs. We have a relatively broad concept of standing. So in contrast to the Gamsu decision that was located in the context of private litigation between individuals, this was already a broader case brought by an NGO. I will soon tell you what was the story behind this case, but I'm starting with saying something about the fact that this is a broader case brought by an NGO, by the way, decided by an enlarged panel of 7 justices. And maybe this is another comment that I should offer before I go on. The Israeli Supreme Court consists of 15 justices. Usually, we sit in regular panels of 3. Just like in India, where the Supreme Court of India sits in ordinary panels of 2 or 3 for the ordinary cases. By the way, we don't have a panel of 2, only 3, but most of the decisions are given by ordinary panels of 3. For bigger, more significant, precedential constitutional cases, the president of the court has the power to decide on an enlarged panel. And usually, enlarged panel signals an important constitutional question that's going to be decided by the court. So the decision that I'm going to review and discuss now, the Commitment to Peace and Social Justice Association case, was in contrast to the Gamsu decision, a decision given by an enlarged panel of 7 justices. So this already signals to you also the awareness of the court itself that it's going to decide a relatively important case, and a very important case in the context of protection of social rights. So what was the story behind this case? In this case, the petitioners, the NGO and other individuals involved, tried to challenge legislation which concerned cuts in welfare programs. We are talking about a period that took place around 15 years ago. Israeli economy was going through a relatively difficult economic stage, and the policy of the Ministry of Finance at the time was to significantly cut welfare budgets, including cutting welfare support to the poor. The average cut was around 30% in the welfare payments, which was for poor people who got relatively minimal support. Taking around 30% of that is very significant for the people involved, because it was about cutting 30% of their very basic needs. We are not talking about here about luxury. Accordingly, the argument made by the petitioners was that this kind of very significant cut of allocation of allocations to the neediest poor people in Israel, this would take this population below poverty line in a way that will affect their human dignity. The argument was that even if we accept only a minimal concept of protection of human dignity, 30% cut, of course, the details of the case are more, there are more detailed nuances, but I'm presenting in a general manner that is enough for our purposes today, that such a significant cut would infringe not only human dignity in a broad sense, but will harm the protection of human dignity, even if we accept a very minimal approach to the protection of human dignity. So, in this case, the challenge for the court was A, to decide whether it indeed approves of constitutional protection of social rights, even when it is vis-a-vis the government, when the litigation has potential influence on budgetary issues and economic policies of the government, and B, even if this is the case, whether the petitioners succeeded in proving that the level of welfare cuts was not only, I would say, stressful for the poor, but also got to the point of harming, I would say, the core of protection of human dignity. Because it is also possible to state that maybe it is a very harsh cut, but if the poor get 70% of what they got before, this may not be the best policy that we support, but this is not the question. The question whether it goes beyond that and even affects human dignity of the individuals involved. So these were the challenges, and now I'll try to describe to you what was the decision. The majority opinion, delivered once again by President Barak, who was already the Chief Justice at the time. President is the term that we use for Chief Justice, was based on the principles that I already described to you. Barak stated that the right to human dignity includes also protection of minimum level of living. So the court was willing to say that human dignity implies also minimal protection of social rights, also vis-a-vis the government. But, and here comes the big but, the court decided that in the circumstances of the case, the petitioners did not succeed in proving that the welfare cuts that were discussed indeed infringed human dignity in this according to this minimal understanding. So this is a very positive decision on the level of theory. We already have the established doctrine of protection of social rights, but when we get to the implementation, the court says, well, but you didn't succeed in making the case in the circumstances of the case, because how do we know that 30% of former allocation really takes people to the most, the neediest position that infers necessarily also harming human dignity. By the way, the court left the door open to the possibility that individual litigants will be able to take their own case to the court and prove that in their personal circumstances, the budgetary cut was so harmful that they cannot really live in any, even in a most, I would say, minimal level and support themselves. But the court was not willing to make the argument that as a general rule for all welfare recipients, this is the case. It only left the door open for individual litigation, and obviously we understand that this option of individual litigation, although in theory it is possible for the neediest poor, this is not a very effective and promising route. If we take into consideration, you know, the emotional energy and sometimes beyond to take one's case to the court. By the way, there was also a dissenting opinion. This was the majority opinion. The dissenting opinion was willing to go beyond that. The minority justice stated that the court should protect not only, should afford not only minimal protection of social rights, but rather an adequate level of protection of conditions of living. And since Justice Levy was willing to support this broader conception of judicial protection of social rights, he was also willing to state that in the circumstances of the case, the petitioners succeeded in making their argument. So, where do we stand? Around 15 years ago, when this decision was given, and then I will soon get to the third part of my presentation and will try to show where we stand today. But in this very important point in the development of social rights jurisprudence in Israel, we got to the stage of, on one hand, accepting the doctrine, accepting the idea that the protection, minimal protection of social rights is part of the constitutional concept of human dignity and should be protected by the court as such, but at that point, not very effective, I would say not very effective, not very activist approach in the implementation of this important concept. Now I will try to see and show what happened since then. What did the court do with this very important landmark decision, and what is the current, I would say, willingness of the courts in Israel to protect social rights? And I can say that in a positive manner, we can say that since then we have new decisions that maybe to a greater level were willing to protect social rights. We should always also think of legal developments as a long process. We cannot expect as lawyers, and this is also, I think, an important message that I would like to deliver to you, being a young jurist, that we cannot always conquer everything in one step, in one litigation. So patience is also a very important virtue in the development of law and even in cause lawyering. So we will see that things happen since then. Not everything happens immediately. At the same time, we also see that naturally, because of institutional constraints, not everything can be gained through court litigation. There are other routes, other arenas. Not everything can be always protected and won by court litigation. Anyway, I'll try to see what happened since then. My next stop, a very important decision of the court, was given in 2012. This is the Hassan versus National Insurance Institute. And this is also a point where I would like to stop and mention that our friend, Professor Neta Ziv, was the advocate representing in this very important social rights case. In fact, the first social rights case in which I think it was a real victory in terms of implementing social rights protection, not only declaring social rights protections, but also actually protecting them. So what was the case there? In this case, the Supreme Court was asked to review the constitutionality of one of the conditions regarding the entitlement to get income support. So we are once again talking about income support. And income support in Israel is the kind of the most basic welfare support offered by the government to the neediest poor, those who cannot be even employed, so some kind of minimal level of support. So in order to get this very minimal level of so-called income support by the government, one has to be first relatively very poor, because otherwise you don't get income support. And there are a few, I would say, conditions and tests in order to make sure that you are among those who are really worthy of this most basic support by the government. And one of the conditions that was written down into the law, and that generally might be reasonable, I will soon explain, is that a person who gets income support in Israel should be one who does not have access to regular use or even ownership of a car. The idea being that if you are rich enough or able enough to have a car, not necessarily a car owner, but rather someone who on a regular basis uses a car. It may be a car of your brother or your sister or a friend, but if you are the regular user of that car, so maybe it's your car even if it's not written under your name. And so in terms of, well, we cannot support everyone, so one of the, I would say, more pragmatic conditions that were written into the law that maybe as a thumb rule, if you own a car or if you are a regular user of the car, you are not entitled to income support. Well, in regular circumstances, this might be okay. I mean, it's a matter of maybe pure rationality. But life is more, I would say, more sophisticated than simple rules. There were cases of people who were really needy, really poor, did not have any kind of real ownership of the car, but maybe they had a very disabled child who they had to take to special treatments, and they did not have access to public transportation, and maybe could not even use public transportation because of the level of need of the disabled person that they supported. So there were cases that we could even imagine that although the rule is, in usual circumstances, is a rational rule, there were some cases in which it brought to completely irrational and unjustified circumstances, results. And what was the problem with the law? The problem with the law was its very sweeping nature. The law, as it was written down, did not leave any place for exceptions. It was a sweeping rule. If you're using in a regular manner a car, no matter what are the circumstances, maybe it's just contribution given to you by your benevolent neighbor because he or she has mercy of your disabled child and wants to support taking him to treatments twice a week. you lose your income support, no matter what are the circumstances. So it was an absolute, irrebuttable legal presumption. And this was exactly the problem. So the petitioners, my friend Netaziv and others, made the argument to the court that this condition, in its sweeping manner, leads to a disproportionate infringement of the life to human dignity, because it is not open to any assessment of the circumstances of the case. And by the way, if one did not meet this standard of not having access to the car, it's not that the income support was reduced. It was completely abolished, so you would get zero from the state, although you are very needy. So in this case, for the first time, the Supreme Court not only said very benevolent words about the importance of protection of social rights, but it also gave a remedy. It stated that the law, in that form, in its sweeping form of completely denying income support to people who use car on a regular basis without any assessment of the circumstances of the case. I mean, only in the sweeping form of the rule, this is unconstitutional because of the infringement of human dignity in a disproportionate manner, human dignity in the sense of securing a minimal level of livelihood. So this is why it's a social rights protection case. So this is a very important case. It was also given by an enlarged panel, and the court, by the way, gave this decision with full awareness that it is giving an important decision. This decision, by the way, was the decision that was read aloud by the retiring Chief Justice at the time, Chief Justice Dorit Beinish, by the way, the first female Chief Justice that we had in Israel. We have in Israel a tradition that a justice, I'm just giving you some kind of a more lively discussion, description of the circumstances. This is beyond the formal legal presentation. We have a tradition of a ceremony in which the retiring justice, who, by the way, we have a mandatory retirement age for justices at the age of 70. So the retirement day of every justice is also the person's 70th birthday. And that justice reads aloud his or her last decision. So the Chief Justice, Dorit Beinish, chose to read aloud this decision on the protection of social rights in the ceremony of her retirement, which, of course, means something in terms of the public arena in Israel, that this was a choice of the Chief Justice, not only protecting social rights, but protecting social rights in I would say, in a pragmatic manner, not only in a declaratory manner, but in a manner that also intervenes in the wording of the law. So this is, I would say, the very important role of the Hassan decision in Israeli case law. At the same time, I would say that although we celebrate this decision, and although this is a very important landmark in our case law, it is important to say that this decision is still subject to the minimum understanding of protection of social rights. It was relatively easy, again, relatively easy for the case. It's never easy, but relatively easy to intervene in this case, because it was really about a relatively cruel result of completely denying income support for people who are really in need because of very, I would say, complicated personal circumstances, and also the budgetary consequences of the decision are not that big. I mean, there are budgetary consequences, but not, at least the way I see it, not great budgetary consequences, because the court did not state that now the government has to offer income support to every poor person with a car. It was only, I would say, stating that personal circumstances should be assessed. And this is relatively, I would say, minimal effect, not a great revolution in terms of budgetary consequences. And maybe for this reason, this was a good case to start the way with something that is bearable also from a pragmatic political perspective. Now, at this relatively advanced stage of the presentation, I will mention briefly two decisions that I already had the privilege of being involved in. So you will gain something of the fact that I was presenting this lecture. I will just say that I was appointed to the Supreme Court of Israel in June 2012, 6.5 years ago. So all the decisions that I've described to you so far are decisions that were given by the court before I was appointed. The last decision that I described to you, the Hassan decision, was given by the court 3-4 months before I was formally sworn into the position. So I could be relatively very objective about the decisions because I could describe them to you as an academic, as an outside reader of the decisions. Now I will just bring two other examples that I warn you in advance. They are not a revolution in the concept of the court, but I think they shed some light on the future challenges that we will have to face. So I will discuss briefly two decisions that are more about future challenges and maybe future questions that we will have to address. So the first decision that I would like to mention is a decision commonly referred to as the so-called vaccination decision. This case dealt with an Israeli law that was in force at the time. It was since changed, but that is less important for our purposes. And that law stated that or accepted some condition to what we call in Israel children payments or children allowances. In Israel, every family gets some kind of payment, national insurance payment by the government for every child of that family. So every person would get some kind of payment, a monthly payment by the government according to the number of children that that person has. This is connected also to broader policies that Israel traditionally had to support larger families. It also has some kind of, I would say, political context in the inner Israeli political debate. I will not get into the details. This is not the subject of my presentation, but this case is connected to these so-called children payments that are given on the basis of the number of children to families in Israel. And at the same time, this is a very old policy that is in place in Israel for decades. A few years ago, the government had a new idea. I may allow myself saying quite a good idea, according to my judgment at least, that it wants to give incentives to parents to vaccinate their children against very severe childhood diseases that may threaten their lives. You know, there are some kind of childhood sicknesses that we can really avoid by getting vaccination. And by the way, vaccination is offered by the government free of payment. So it's not that the poor had to vaccine their children and pay for it and take from the food in order to vaccine. Vaccination is offered as part of the protection of public health in Israel, and public health, right to health is also another aspect of protection of social rights. So the government had this policy of giving children payments to every family in Israel according to the number of children. This was the old policy. And the new policy was a policy that was focused on how to give incentives to family to take this offer by the government of free vaccinations to their children. And the way to connect between the two at that time was the government succeeded in making an amendment to the children payments law stating that parents who are not vaccinating their children, who are not taking this so-called free offer by the state to vaccinate their children in order to safeguard the health of their own children as well as the health of the population at large, will not get full children's support. Something will be taken out of the children's support in order to give them the incentive to vaccinate their children for the best interest of their own children, because some people, for various reasons, are afraid of vaccinating their children. They have all kinds of reservations against that, and the government wanted to give incentive. And this law that we can understand on one hand as a law protecting public health, on the one hand, but it can also be understood as a law that is taking away support from the poor who are not willing to vaccinate their children. So a few petitions were brought to the court attacking the constitutionality of this condition that was added to the children payments law, arguing that this is a law that is infringing human dignity because it takes away some kind of support, of economic support to the people, although, of course, the people are free to guarantee full payment. How? By vaccinating their children. It's their own free choice to do that, and it doesn't cost them money. Why do I think that this is an interesting case before I even present to you the answer of the court? Because in contrary to former case law, in contrary to former examples that I showed to you, this is a case that is actually about a clash between the protection of two social rights. Because the right to health of children is an important social right, and it is clashing, it is conflicting in the circumstances of the case with another potentially important social right, the right to get income support by the state, especially for poor families, and the concern that especially poor families will be harmed because the rich don't really need this support by the government. It's not significant enough in terms of their total income, so they may get children allowances by the state, but they don't really care. It's not significant in the planning of family budget. I will not get into all the details of this case that I was involved in, but I can tell it was decided by a three justices panel, and I was among of the justices on the panel. There were nuances in the reasoning of the three justices, but I can tell you that we all agreed that this petition should be dismissed, that the policy of the government in these circumstances did not really harm protection of social rights. Why is that? Because it was not a case of necessarily infringing, the rights of the children, because it was also about protecting the right of health of the children, and the level of discount of the children protection was very slight. It was a very small part of the children payment that was afforded by the state. So it was not really about taking most of the payment. It was a relatively minimal discount in children payments in order to promote the protection of another important social rights, that is the protection of health. So I don't know what you would think, and there might be other possible answers to the dilemma of the case, but personally I can tell you that as a justice I felt okay. I felt very secure in my decision in this case, because it was not a case in which the government wanted to limit protection of social rights in order to promote economic policy or something else that is beyond discourse of human rights. It was about promotion of human rights by minimally affecting other human rights. So it's like an inner clash within the arena of protection of human rights. This is why I brought this case, because I think this is a unique case in this sense. It's not the classical clash with government budget as we saw in the commitment to peace case that I mentioned before. Another, and maybe last example that I will mention, concerns, I would say, a series of cases, but I will characterize this other group of cases by only describing one example, but it's one example that would stand for many others of this kind. It is the issue, the whole issue of protecting social rights of individuals who may be deemed or described outsiders to Israeli society. So far, I was focusing on government and judicial protection of social rights afforded, I would say, to the natural political community of Israel. That is Israeli residents and citizens. But as we know, especially in global economy, not only residents and citizens of the country live in it. There are others who live sometimes, many times, on one's territory. There are migrant workers, there are refugees, there are many people who are not, I would say, the typical members of the Israeli political community, but there are people who live in Israel. And the question is, what would be the judicial approach to the protection of social rights, not of residents and citizens? And this is, I think, a very important question, not only in Israel, but also in other contexts, especially in global economy. So we cannot think only of the members of our own community. We have to see, the public arena as it is. In addition, we have here a very difficult challenge. Why is it so difficult? Because on one hand, we do understand that, and I think it is okay to say, that a country has some kind of additional duties towards its citizens and residents. It's usually okay for a country to give additional protection of health coverage, etc., to its citizens and not, for example, to any tourists. There are different levels of attachment to a country, and we would expect it to be okay for a country to make distinctions. These distinctions are usually completely not okay in the context of the protection of political and civil rights. We would not say that if a person is not a citizen, so he doesn't have a right to freedom of speech, for example. But in the context of social rights, we do acknowledge that there is some legitimacy to making distinctions between the insiders and the outsiders. But this distinction does not mean that the country, that the political community does not have any kind of duty towards people who are outsiders. Migrant workers also should enjoy social rights and some minimal protection of them. Maybe Israel is allowed to give them less than it gives to its citizens, but it doesn't mean that it is allowed not to give them anything. And of course, I use here Israel as an example, but it's a challenge to every country in the world today, and especially for developed economies where there are more outsiders who keep flowing into the system, and the question is, how would they be treated by it? And here, in this context, and I want to say that one of the real challenges for Israeli jurisprudence, and as well as to jurisprudence of other judiciaries in the world today, is how to secure some level of protection of social rights also to people who are not residents and citizens, acknowledging the legitimacy of the distinction, but still acknowledging also the duty of the country also to people who are not citizens and residents. And the question is how exactly to draw the line. And a typical case, and there is a long line of cases, but I will bring only one example because I think, A, that it is a good example, and second, that I was also involved in that, so I thought maybe there is a additional advantage in this sense. And this is the case that is known, this is not a formal name, but the name of the case is the case of health insurance of nursing employees. And here is the basic story. It is a decision from 2014, so relatively new. The decision concerned regulations which set the standards for mandatory health insurance coverage that employers have to buy for domestic nursing employees. The social phenomenon in the background is the phenomenon that Israel imports migrant workers, especially, or one of the areas in which migrant employees are used excessively are in the area of nursing aid to disabled and the old people and disabled people who need daily support in their homes. And this area is heavily regulated, and one of the regulations states that employers who import migrant workers have to provide to their migrant workers mandatory health insurance, and there are criteria. What is the minimal level of health insurance that should be given to employees in order to really secure that also migrant workers get good health treatment as long as they work in Israel, and I think this is very important legislation. But the petition concerned one of the conditions that was attached to the regulations, and I believe this is a very important and interesting case study to assess the level of entitlement and the level of duty towards migrant workers who are indeed not citizens, but still are human beings and should be protected. And this regulation stated that indeed employers must buy this relatively good health insurance to their migrant workers, but there was an exception. The exception stated that the migrant worker, the insured, would lose his or her insurance after 3 months in which that worker cannot work anymore. So it was a relatively good health insurance policy for those who can work. But if one got a really severe disease, such as cancer, God forbid, or maybe a car accident, something that will affect the ability of that employee to keep on working, that is, recovery is beyond 3 months, so it's a relatively serious thing, not something that is relatively easy. So after 3 months, health insurance expires. What does it mean if we think about it sensibly? It means that you get health insurance as long as you are healthy. Well, we usually need health insurance not for the cases in which we are healthy. We usually need health insurance when we are unhealthy. So this was a very, I would say, efficient kind of health insurance from the perspective of the government and the employers. We will provide you, the migrant workers, health insurance as long as you can work, or as long as you have a future ability to work. If not, well, impliedly it means go back to your home country. We don't need you anymore. This is a very, I would say, harsh message concerning the human treatment of migrant workers, and we as the court intervened. We accepted the petition. We said that this is an inhuman condition in the health insurance provided to migrant workers. The case, by the way, involved not migrant workers who came to Israel and lost their ability to live after a few months. It was the case concentrated on people who were living in Israel maybe 10 or even 15 years, gave much of their livelihood and energy to people in Israel, and once they become ill, we say, okay, sorry, we cannot support you anymore. The court said, you cannot do that. If we're talking about protection of social rights in a manner that is connected to human dignity, so part of treating migrant workers in dignity means that we respect them as human beings also when they lose their ability to work, and not only when they retain their ability to work. At the same time, since we are only a court, we are not an institution that makes economic, I would say, that shapes economic policies. We told the government, we are not telling you how to secure the health coverage to migrant workers. If you want, finance it yourself. If you want, make the employers buy a better health insurance. We are not telling you how to do it. All we are telling you is that you cannot go on with the policy that you had so far. So I think this is a good example for, I would say, a case discussing social rights, because here we cannot speak only in abstract terms. Do we believe in social rights or not? We have to be very nuanced and see what is the level of possible judicial review in this area. So as I get to the really last part of my presentation, and still I have to leave a few minutes to your questions, and if you have them, I hope, still try to think. If I want to wrap up and sum up what I said so far. So going back to where I started, I will say that social rights were not included explicitly in the basic laws from 1992. This is where I started my presentation. And these basic laws still are used as the basis for protection of social rights through the concept of human dignity. The question is how to interpret human dignity, whether to give it minimal meaning or beyond. And I think that from the last cases that I described to you, we could see that even subject to the limitations of the case law, it is possible to promote the protection of social rights as a derivative right of human dignity, but subject to the institutional limitations of the courts. Courts are, after all, secondary players and not the, I would say, the first players in the arena of protection of social rights. Thank you for your attention. So if you have any questions, you can present them. If you feel uncomfortable about presenting them in that big room, so you can also approach me after that. I'm here. Yes, please.
Hello. Okay, hi, good afternoon, ma'am. I'm a final year student. Thank you for the very important talk. I think especially keeping in mind that a lot of us have already done the Indian Constitution law, we were able to appreciate the many parallels which courts in India and Israel have adopted, especially something like expanding the ambit of socio-economic rights by expanding dignity, which is present under Article 21 of the Indian Constitution. However, my question is regarding the policy of judicial review, which courts in Israel have adopted. If I understand correctly, the Israeli courts have held very few laws unconstitutional since the very beginning. I think less than 20 laws have been held unconstitutional. Can you tell us what are the major reasons behind it? Is it a reason of general deference by the courts to that of the legislative actions? Or is it because of the absence of a formal constitution as such by which the courts are not really able to hold a lot of laws unconstitutional?
Again, I want to make sure that I got your question. You're asking why the court seems to adopt a relatively narrow approach to judicial review. Okay, this is a very interesting question, because it's very interesting for me to realize that from your external perspective, the court adopts a relatively narrow approach. because from the perspective of the inner public political discourse in Israel, the court is usually accused of being very radical and activist. And I suppose that the answer lies somewhere in the middle. I think that you offered yourself the answer. The answer is that it is more difficult to establish legitimacy of judicial review of legislation when we still lack a full formal constitution. Because a constitution is not only a legal document, this is also something we discussed yesterday in the constitutional law class. It's also an educational tool. If children grow and know from elementary school that the Constitution is the beating heart of the nation and that judicial review is part of the maybe contribution of the court to the livelihood of the nation, then court intervention, so-called intervention in political decisions is regarded more legitimate by political actors. Nowadays, a very hegemonic view in Israel, a view that I don't support naturally, but many, I would say, leading politicians accuse that the court intervenes in public decisions without proper legitimacy. By the way, I would not say, I think, this is at least my own judgment, I don't think that the court is is necessarily as hesitant as might be expressed in my presentation. I think that the case study of social rights is an especially hard case study for establishing the legitimacy of judicial review without a full formal constitution. The legacy of judicial review in Israel is more established with regard to civil and political rights that don't have this, I would say, extra burden of, budgetary constraints, etc. But I'm very thankful to your question also in the sense that when I go back to Israel, I will be able to reflect to people that when I visited India, the general impression was that the court is conservative rather than radical, as people tend to think in Israel. Yes, please. Yes, you.
Good afternoon, ma'am. Ma'am, so my question is a bit more fundamental in nature. So what we have learned in our classes is that constitutional law is looked at as meta law. And my question is flowing from the discussion we had yesterday on basic structure. So the doctrine of basic structure itself is standing because constitutional law is considered as meta law. So my cursory understanding, my cursory reading on the Israeli system was that there is sort of a debate going on regarding the supremacy of basic laws in the country. So my question was, is that debate still going on, and what are the two sides of this debate?
Okay, so first of all, a big yes. This is a debate that is really going on as we speak right now. And I can tell you that we have forthcoming elections in April, and the issue of the role of the court and the level of legitimacy of judicial review is certainly, a subject for public debate. What are the two sides of the debate? Well, I would say that people on the more conservative side of the political map, of course, I'm not taking any political stand, I'm just describing. Judges are considered to be and have to be neutral, so I want to stress that. People on the conservative side say that judicial review is legitimate when a country has a full formal constitution and then it is introduced expressly in a document and the court is given power, and also the limits of this power are clear. Some people make the argument that if the court wants to practice judicial review and therefore become some kind of a political player, so maybe the appointment processes for justices should be different. Maybe politicians should have more influence on the process of electing justices. Again, these are not arguments that personally I agree to, but some people make the simplistic argument that why should we go to elections? We vote for a government, but eventually those who make the real decisions on public life in Israel are the judges, and we don't elect them. So why do we have a democracy? This is the kind of the counter-arguments that we get. Obviously, I believe, also a constitutional law professor, not only as a judge, that these are too simplistic arguments, that we know that every democracy should have mechanisms of checks and balances. We know that democracies also tend to infringe on rights of minorities, and therefore that it is very important to have counter-majoritarian mechanisms in every, I would say, healthy democracy. But if you ask me what are the contours of the discourse, so these are the contours of the discourse. Yes, please.
Ma'am, you said that under certain situations it would be possible to deny social rights to migrants. However, if these migrant workers are those who are contributing in taxes to the state's funding, and these social rights are provided for out of these taxes, wouldn't they be entitled to receive the same amount of aid as would be provided to citizens?
Again, my main argument was not that I'm against, protection of social rights of migrant workers. I think that my main argument was just on the opposite way. But I think we can, so basically I believe that of course protection should be afforded to migrant workers, but I think that at the same time there is a distinction between what a country gives people who live in it as a matter of human rights and what it is giving to them also beyond the necessary protection of human rights. Because let's think, for example, about maybe university tuition, which may be part of the right to education in the broad sense. Wouldn't it be reasonable or at least legitimate to make a distinction and say we'll give extra tuition support to citizens and not to non-citizens? So at some level, I think we will all agree that there are different levels of memberships in a political community. I say that with a full respect to the fact that we should treat migrant workers and refugees also as people who have rights that should be protected, but I think an acceptable view that there are levels of membership in a community, and I think that we can live along with this, I would say, dual statement. Yes, please. Just take the microphone so I will be able to hear you.
Thank you. I just had a question regarding the extent to which basic laws are applicable in Israel, particularly in the private sphere. Because, for instance, in India, fundamental rights can only be enforced against entities that are state or deemed to be state under Article 12. So, considering the wording of the basic law seems to be more broad, and considering dignity has been interpreted so broadly, would it be easier to say social rights could be enforced in the private sphere in Israel in that sense?
Okay, so I think the issue of application of human rights in the private sphere is a general question that goes beyond the question of social rights, because we can ask in the same manner, to what level do private people have to respect equality when they in their commercial dealings, for example, with others. So first, it's not only a question of social rights, it's a general question regarding theory of human rights, what are the level of application vis-a-vis the government, and what are the levels of application vis-a-vis private individuals. The hegemonic doctrine in Israeli constitutional law in this regard is that human rights don't apply directly in between private individuals, but they do apply indirectly. In what sense? In the sense that, for example, sometimes core terms and core concepts of private law, such as bona fide, reasonableness, etc., are interpreted in a way that is influenced by a human rights understanding. And by the way, the Gamsu decision that I started with is an example for some level of application of social rights in a private law scenario, because it was about enforcement of death in the area of family law. So I think that at least to a certain level, social rights will be protected also in private litigation, but subject to the awareness that we are talking here about a clash between two individuals, that both sides have rights, and therefore the level of protection will be diminished in comparison to what we can expect in relationship vis-à-vis the government.
Thank Justice Daphne Barak-Erez for an extensive description of cases which have tried to advance a conversation on social rights. With us for a few hours here in the afternoon. So if you'd like to speak to her directly, you can speak right now, or as if. And we are very grateful for you to spending a couple of days with us and having an extensive couple of conversations with us.
Thank you.
So, yeah.